Immigrants, when a U.S. citizen or a green card holder petitioner dies, their immigration petitions that they filed for their family members usually also die. But there are three ways a case can continue despite the fact that the petitioner is dead. First, widows and widowers of U.S. citizens, they can stay in the immediate relative category even after the spouse's death. The marriage must have been legal with no divorce or separation, and the survivor cannot remarry before getting their green card. If an I-130 was already filed before your spouse's death, USCIS can convert it to a self-petition under the I-360. If not, the widow or widower can file the form I-360 within 2 years of their spouse's death. Children under 21 may be included, and no affidavit is usually required. This is the broadest relief when it comes to death in immigration. The second option is a relief under Section 204L of the Immigration and Nationality Act, which protects surviving relatives of petitioners more broadly. It covers many family and employment-based cases such as refugee, asylee, UT, visa derivatives. Now, the key requirement is that the family member that was to benefit or continue to benefit despite the petitioner's death, they must reside in the U.S. at the time of the petitioner or principal's death with continued residence in the United States. Now, if one beneficiary meets that rule, all the derivatives will qualify. A substitute sponsor may need to sign an affidavit of support, and USCIS treats the death itself as proof of extreme hardship for waivers. These cases are usually approved unless granting them is against the U.S. public interest. The third and last option we're discussing is the humanitarian reinstatement, which applies only when an I-130 was already approved before the petitioner died. It's available only to the principal beneficiary, not derivatives, and it is fully discretionary. The request is made by filing something called a humanitarian reinstatement request with supporting evidence such as the impact on U.S. relatives, health, age issues, community ties, or long delays. A substitute sponsor must also provide an affidavit of support. Remember, this is discretionary, and so it typically cannot be really appealed. It makes it the narrowest option in the case of death. I hope this video helps. My name is AK, attorney at AK Poku Law. Hit that follow button. Contact us if you need our help. We represent immigrants in all 50 states in the United States and around the world. I'll see you soon in our next video. Bye-bye.